Good evening and welcome to Slam the Gavel, the show that tells it all regarding family court and CPS, co-parenting, and marriage issues. I'm your host, Parens Patriae, and today I've got a great guest. His name is Michael Sayen. He's written a book and he's here to tell you about it. Good evening, Michael. How you doing?
Hi, Mary.
Hi.
I'm doing horrible, and that's why we're in this game. We don't go to a hospital unless we're sick, and we don't go to family court unless we want to be totally destroyed and have our families ripped away from us. So,
well, I'm glad you're here to talk about it.
Yeah, thanks.
And we're here to listen and learn because you've also written a book called "The Cure for Divorce in the Kingdom of God."
Right. Yeah. Let me. And I asked Mary if I could kind of tell you a little bit of my history.
Sure.
Walking down, and we all have our all individual histories. We have people from all different sides of the world involved in this movement to really save families from the government, because our enemy today is not our ex-spouse, is not the crazy spouse or the abusive spouse. Is our enemy is really the government and the interjection of the government. And that was a warning from us, from the Federalists and the Anti-Federalist papers back in the late 1700s. So they warned us that the government could possibly outgrow its britches and have an effect in our lives, that we would turn back into Great Britain, and we would have a tyrannical type government, and that's where we're going. And that is where, because when government gains more power, people gain more power, we grow more like the country that we fled back in the 1600s each day.
Oh, I can see that. There's just so much wrong with the system. The system is broken, and we're all paying for it.
Right. And and it was really interesting, because back in the days when we were putting together the Constitution and Declaration of Independence and fighting from Great Britain and the tyranny, the human, our inalienable rights being basically torn away from us, our human rights violations by the king and by the king's courts, because the king appointed judges and paid the judges that were here in America, and they basically, that's how the King of England was able to tax us, was able to control the United States. It was through the courts, and through, and you'll see that in the Declaration of Independence. One of the great things that we speak about, there's a listing of abuses that we give, enumerated abuses that we give for the king, of why we're going to separate from him after many, many warnings. And one of them is the abuse of the judicial system, how he paid and how he's able to control the judges, because if you control the judges, you control the law. And if you control the law, you control the government. And that's one of the fears of the Democratic Party today, as they're starting to realize that legislations in Congress are not writing our laws. Who are writing our laws are really the judges, and they're legislating from the bench, meaning they're making doctrines, or what we would call stare decisis, or precedents. They're making decisions that turn into basically law, because as their decisions is passed from courthouse to courthouse, from federal to state, we're basically being ruled by the very judges that were appointed. And so that's why there's such a big whoop-de-doo right now, and looking at the filling of the Supreme Court seats.
Yes, it's where the best interests of the child supersede their parental rights, and the judges don't care.
Right.
Just having problems with that.
The best interest of the child standards, that actually was nothing more than an extension of Parens Patriae, the Latin term that was designed in around 1608, and England brought over to the United States. Parens Patriae was a horrible doctrine, that because in England we had the king was sovereign. So we bring over laws from England. However, we can't bring over the supremacy from England. And it's called the Leviathan Leviathan doctrine, where the king has ultimate control, the government has ultimate control, and that's how the people are kept in line. So what happens are many of our laws were brought over from England to the United States. Matter of fact, all of our laws were. That's where we get our legal system from. But there was some awful doctrines that were birthed from England and brought over to the United States. And one of them was Parens Patriae. And Parens Patriae is a Latin term for that the nation is the parent of the child. And so what would happen is the nation being the parent of the child, they would activate it only when they believed that the nation had to decide what was in the best interest of their children meaning your and my children. So Parens Patriae doctrine would supersede parental rights in England. And that wasn't a problem with them because you deal with supremacy. But here in the United States, where we the people have supremacy, we're running into huge problems because Parens Patriae doctrine is superseding constitutional rights of the parent.
Well, this is just not a good thing. And I know of someone, I don't know who it was, that said the judiciary would be the downfall of this country. And I don't know, I don't know who quoted it or said it, but it's happening. Make it stop.
Yeah, well, that happened because what happened was, one of the interesting parts was when the United States was coming as a nation, we decided to rebel from Great Britain, and we formed the Declaration of Independence, where we declared our independence from Great Britain. We did two things on the Declaration of Independence. We established our government, number one. We established a type of federalism, which I'll explain. And then number two, what we did is the government promised, or the signers of the Declaration of Independence representing our new government, promised that it would protect our inalienable rights and not become tyrannical as England was to the United States in the late 1700s. So it promised us certain unalienable provisions which unalienable rights are nothing more than your human, natural, God-given rights that are not given to you, but that you have before the actual formation of the government or state. And they basically recognize those rights, and they recognize those rights are not given to you, but they're inherited from God. Some people want to know where unalienable word or inalienable word comes from. Unalienable is non-transferable, so non-inalienable is transferable. It's a 3rd century BCE term. It's a real estate term. It means non-transferable, that they would use dealing with real estate or land or property that wouldn't be able to be transferred from one party to the next. So unalienable rights means that these are rights that can't be taken away by due process. However, we have a problem because on the Constitution, we have supposedly unalienable rights protected, but it has a caveat in there, and it says, hey, life, liberty, and property can't be taken from you except by due process. So the due process is a conditional clause that offers the government to supersede your God-given natural human rights. And this is a violation of the Declaration of Independence. And people realize this in the early part of our Constitution and jury system. And the argument for the Declaration of Independence has been used in over 100 United States Supreme Court cases as of to date. It's looked at as a contract. It's called a unilateral social contract. Mm-hmm. It's a contract that the government has for its people. However, the courts don't look at it as a contract. They look at it only as a important piece of document. So what happens is your inalienable rights really have zero protections in any kind of jury system. That's how come you can't argue your inalienable rights, even in the Supreme Court, because though it's recognized in spirit, it's not protected by law or by contract. That's a little bit more technical, but those are important things to know because people still want to argue the inalienable rights in courts. But as time goes on, where those inalienable right protections are fading away. So now the arguments against unalienable rights, you'll probably only hear about that. Those arguments are had to do with children who are not yet born. And there's a lot of arguments in the state Supreme Court and the federal Supreme Court as far as the unalienable right of children to be able to live outside the womb. But besides that, you're not going to hear inalienable rights, and especially in regards to the parent-child relationship. That has gone away.
Okay. I know we were talking earlier, like back in 1969, things started changing, and there was a child standard statute. We were talking over the constitutional rights, unalienable social contracts. I think that's what we were talking about, like the 14th
Right, well,
and 15th Amendment.
Right. So it's kind of important to understand how the Constitution and your amendments and your unalienable rights work. So the Declaration of Independence was a mission statement of the government. It was saying, hey, we promise that we are a government. We're an independent government. We give a list of abuses of the king. And then also we promise that we're going to protect human rights. Now, there was not a numerated, meaning it was not numbered. It didn't give a list of those rights. Well, what happened was, as that happened, about 10 years later, we decided, okay, we need to act upon that mission statement, the Declaration of Independence, the establishment of our government, and the protection of inalienable rights. We have to figure out how this new system or how this new government's going to work, right? We made the promise, right? We gave the Declaration of Independence. We won the war. Now it's time to actually, put our foot where our mouth is. So the Constitution was designed to actually do that. The Constitution was wonderfully, wonderfully drafted. Great men, they talked about it. It was actually amazing the amount of research and literature. You can see this when you look up Federalist Papers and the Anti-Federalist Papers. You can see these were people that were representing one party or the other, either the Federalist or the Anti-Federalist movement, and they would basically print in a newspaper their position to kind of educate the people, and the people to have a say on how they think this government should work, because they wanted to keep the supremacy to the people. And federalism is basically saying the federal government has power over the people. We grant them the power over us. However, their power over us is enumerated in few, meaning that they only have very few enumerated powers. If it's not specifically mentioned in the Constitution, if their power is not mentioned in the Constitution, that means that the federal government doesn't have that power. Now, it says, it tells us in the 8th, 9th, and 10th Amendment that any power not mentioned is reserved for the people in the states. So that means that whatever is not specifically enumerated in the Constitution for the power of the federal government, that the rest of the power has to be divided between the states and the people. So when that happened, they're like, well, how can we run this nation where we, the people, have sovereignty? We have inalienable rights. So this was as they designed the Constitution itself, and then eventually they got it ratified. One of the deals was that the Federalists are the ones who put together the Constitution of the United States, and the Anti-Federalists were the ones who were kind of opposing it. So the Federalists said, hey, we'll put together this Constitution, and the Anti-Federalists said, well, hey, we want to make sure that the federal government doesn't come too powerful, just like England was. And so the Federalists promised that, hey, after we ratify the Constitution, we'll go back and we'll create amendments that will protect the people. Basically, the inalienable and alienable rights of the people. We'll go ahead and guarantee those after we get the Constitution ratified. So after the Constitution was ratified, shortly after, they came up with the 10 Amendments, and that's why they're called the 10 Amendments or the Bill of Rights, because they were added later. They were amended later. So they were amended later, but it became problematic because in 1833, the United States Supreme Court said, well, you know what, the added Bill of Rights, the amended rights, they don't apply to the states, meaning that the states don't have to adhere to their citizens or their people's rights that are mentioned. The Bill of Rights, the United States Supreme Court said the Bill of Rights is only for the federal government, is to protect the federal government from superseding the state's power. I know that's really kind of hard to understand, but in a nutshell, what the United States Supreme Court did is saying that hey, only the federal government has to honor a Bill of Rights. The states do not. And so starting from 1833 until the next 14th Amendment, the individual had zero rights from abuses of the state. And the state could abuse an individual's rights and human rights till the cows came home, all the way until 1876, where the 14th Amendment was added, and that was to include some of the human rights protections to the states, or require the states to protect those. And that was designed because it was part of the slavery amendments to that the federal government had to step in saying, hey, you states, you need to protect, blacks, colors, and people of all races from abusing your power or allowing slavery to continue on.
Wow, that's a lot of information. It's so fascinating that history went this way, and and it's just going where the from the civil rights to the parental rights, things just seem to be crumbling lately, or
That's
or
right.
they have been.
That's right. And some of the dissensions in the Supreme Court rulings, they actually said one of the dissensions, I believe it was Justice Scalia, I could be wrong there, it might have been Stephen, but one of them said that, hey, the parent-child relationship or the parent-child is not an inalienable right, is not protected by the Bill of Rights, is not protected by any of the 10 Amendments. I don't want to go in too much more detail, even though it's important to say on the 14th Amendment, life, liberty, and property was the only things that the federal government required the states to protect of its citizens, for the state citizens. However, what the Supreme Court had said, because of some of the wording in the 14th Amendment, it was called an inclusionary doctrine. And this inclusionary doctrine said, the Supreme Court said, well, the other amendments, the 1 through 10, the Bill of Rights, should apply to the people by the kind of the language that's used in the 14th Amendment. So what they said was, hey, as Supreme Court cases come before us and we include those rights under the 14th Amendment, then that amendment applies to the people to protection from state abuses. Now, the reason why that's important, because number one, all the Bill of Rights do not apply to us. That means that your state, there's some things that your state can violate, that the first 10 Amendments still does not apply to you, because the Supreme Court has not included it in there, or they didn't really think that it was necessary. Now, the majority of them have. However, what we do is we have an interesting caveat, and people need to understand this because this is very important, is that the first 10 amendments that were created, they were designed to be unalienable rights. There is no conditional clause. Like, it doesn't say, hey, you have freedom of the press, but by due process, or you don't have freedom of religion, but by due process. The only due process clause was mentioned was in the 5th and the 14th Amendment. Those are and other than that, all of your rights were considered unalienable. But what happened was, after the 14th Amendment and the inclusionary doctrine, saying that, hey, we'll start including these under the 14th Amendment, therefore they started to apply the due process clause to every single amendment or right that you have. So they'll say, oh yeah, you have freedom of religion only by due process, which means you don't have any freedom of religion until they say you have it in a due process setting. Does that make sense?
Yes.
And the reason why that's scary, because what it does is it adds a conditional clause to all of our inalienable rights. So we have 0 inalienable rights right now. All of our inalienable rights, life, liberty, property, everything, freedom of religion, press, anything, you name it, is all under the 14th Amendment, which says, hey, you only have these rights after, or when the state says you have it, after a hearing, or after a trial. And the problem with these is that we have the protections for the jury trial to be judged by our peers. But now, as the courts, they're fading away from this, and the family court, specifically juvenile court and so forth. And so what that means is that you're not getting litigated by a jury of your peers, which is to protect you, but you're being litigated by somebody in the government who has a probably or possibly a biased slant towards power. And this is just, like I said, it's become an evil empire, because when you understand going back a little bit in history, when you understand the Magna Carta was originally designed under knife point to the king, because the lords were getting, basically the king was overtaxing and over-controlling the people through the judicial system, through their traveling judges. And he was becoming extremely rich. Well, what happens was the lords of the land said, hey, we had enough. And then basically by knife point, they made the king sign the Magna Carta, saying that, wait a minute, two things. Number one, the king also has to obey the laws. And then number two, we're going to be only judged by our peers and not judged by you or any of your governmental officials who you either could pay off or has 100% judicial immunity. But what happened was these courts of equity, or basically courts of supremacy, came from England, that they disbanded in 1875. We actually started our family court in 1910 under a false system, and we're giving our judges complete supremacy, and that's why we're not able to get our rights protected in the state appellate courts or the Supreme Court, because when it comes to discretion, the judges have 100% not only immunity, but they have supremacy as well. And the state courts and the higher courts are just not overturning these lower courts' decisions.
Well, this is terrible, because I have been in court myself with no due process. It has been a nightmare in the family court system.
Correct. And the question is, who's going to protect your due process, right? They say due process, but what does it mean? Now, due process literally only means procedural due process. That means that you have the same, you should have the same rights afforded to you procedurally as other people in your community. Now, if you, however, it's not substantive due process, meaning that it doesn't have any substance. It's just basically, are you following the court's rules and procedures, right? But as we know, the judge can abuse discretion anytime he wants in a family court setting or juvenile court or child protection service setting. And that's because, number one, there's no oversight. And that's, again, we're looking at courts of equity are based off of the king's courts of supremacy. That's where they came from, England. It came from the king's court. The courts of the chancery were actually the keeper of the king's conscience. That was the nickname. And they were a direct line from the supremacy of the king, or the direct authority of the king himself. So they were designed so that our judges have complete, not only immunity, but complete supremacy. And that's how come our upper courts will not challenge a discretionary decision of the lower courts. If the judge makes a decision based on discretion, not based on hard law or the rule of law, the appellate courts and your state Supreme Court simply will not overturn them. Now, secondly, on the due process, so hey, just going to court is due process. The United States Supreme Court had said in one of its rulings that due process includes both procedural and substantive. And when it's dealing with a fundamental right, the United States Supreme Court said that since it's substantive, means that you should have your fundamental rights should be protected under the highest level of scrutiny possible. That means with little government influence, and also to be able to look at critically, and to be able to be that when they make a ruling on you, it's the least restrictive means possible, and it's to give you the greatest preference towards your rights or human rights. So the Supreme Court is saying, yes, hey, the people have these inalienable rights, but the lower courts are not protecting them. Now, the problem is the reason why we don't have any judicial oversight in the federal courts is because something called the Rooker-Feldman doctrine, domestic relations exemptions, ex parte Young, and Young abstention. These are some things that are doctrines and so forth that was basically an extension of the 11th Amendment. So the 11th Amendment says states have supremacy over the federal government, and the federal government shall not interfere with state courts' decisions. That's the 11th Amendment. Well, the problem is the 14th Amendment says just the opposite. The 14th Amendment says the federal government has the right to interfere with state court decisions if it's in a violation of your life, liberty, or property, which when you're dealing with family court, that's exactly what you're dealing with. You're dealing with violations of human rights. So you're not looking at, your people are not concerned about losing their boat and losing their house. They're concerned about losing their children and losing their family. So the lower federal courts, the district courts and the circuit courts, are not taking cases because what they do is they're throwing the flag of federalism up in the air, and they're saying federalism, and therefore we don't have to hear any of your state court violations of due process in your state courts anytime that it's a completed decision. And they're screaming federalism, they're saying 11th Amendment, and everyone else is going along with that. And the problem is that legislation or Congress are the ones who are supposed to make laws to protect our 14th Amendment under Section 5 of the 14th Amendment. But however, they are not. Legislation and government being directed, supported, and really guided by the American Bar Association, and also the women's rights associations as well, but more about the Bar Association. They are not passing any kind of law that's really not supported by the bar that's going to protect our due process rights protected to us or promised to us in the 14th Amendment. I know that's a lot. Did you get any of that?
Yeah, I did. It's very, that Rooker-Feldman doctrine was a bad decision by the U.S. Supreme Court. That should not have happened.
So yeah, so the Rooker-Feldman is that the question when it comes to Rooker-Feldman is, who has supremacy? Is the state have supremacy, or does the federal government have supremacy? Now, when the United States was designed, we the people had supremacy. The state were seconds, and the federal government was looked at as third or enumerated powers. The problem is when the 14th Amendment was established, it reversed federalism. So it's very important to repeat, the 14th Amendment reversed federalism, and what it did is it gave the federal government power to supersede the state's supremacy in any violations of life, liberty, and property, which is almost anything. If that makes sense? So the federal government, originally by the Constitution, had enumerated and few powers that were mentioned in the Constitution, and they were very, very specific. But however, when the 14th Amendment came, it became very, very vague, right? Life, liberty, and property. That's a very vague concept. And so that vague concept was given to the federal government. So the federal government, by the 14th Amendment, reversed federalism, gave itself supremacy, and by that, it gave itself the power to supersede state laws. But the problem is that federal government doesn't want to handle all of our divorce cases and custody cases. They simply do not want to handle it. And because of that, they're claiming, the federal government is claiming, we believe in the 11th Amendment. We believe in federalism. And we'll only activate the 14th Amendment when Congress says so, or when they legislate it to be. And so basically, they're basically saying, hey, we got all the power. However, we're not going to use it unless it's in our best benefit.
And then it's turns into the best interest of the child. It just goes kind of, you know, with CPS was designed for
Well,
child
right.
trafficking.
Well, what happened, right? And the important part is to know when you understand history, you can understand a lot. So when you understand the best interest of the child standards, where did that vague concept come from? Well, it actually came from Parens Patriae doctrine, Latin term, back in the 1600s. So what happened was the nation, the courts of equity, there was two courts in England. They had common law courts, which were traveling courts, and they also had courts of equity that were later designed to be the King's Court. Later became the Lord of the Chancery, the Chancery Courts. These are courts that people in high position in both government and the church held. So it was, they basically were either bishops or having a high position both in government and the church. They would use canon law and civil law, or what we would say maximums of equity. And they would use these principles of morality and ethics to make their decisions when it came to the equitable courts. However, the equitable courts didn't handle divorce or childcare. The courts of equity, or I should say, basically the Church of England, handled divorce and the distribution of children and property of divorce and marriage, all of it in England, up until 1857. And then what happened was in the early 1830s, the women's right movement started to come up in England. They wanted the ability to be able to supersede the church doctrine that didn't allow women to initiate divorce or to divorce their husbands. And they cried to Parliament. So Parliament took the power of divorce away from the church to be able to grant to women the power to be able to divorce their husband under extreme cases of adultery. So what happened was when the government took control of the divorce, then we're starting to look about these separation of children. But in the 1600s in England, the government wanted to be able to step in for abuse or neglect. And so what and children were under property laws, children, wives, and slaves were under property laws in England and in the United States till about the beginning of the 1800s, so about 1830s, 1850s, most states. So they were under the property law. So what happened was the state really couldn't intervene. Right, you heard of the rule of thumb. You know where that derived from, right?
I do not know.
Okay, so the rule of thumb was a twitch or a stick that you could beat your wife with, but the law said that stick couldn't be thicker than your thumb. So the rule of thumb was, hey, you could beat your wife as long as you didn't leave a mark, and as long as that twitch wasn't bigger than your thumb. So that was back in the 1600s all the way to the 1800s, and even before that. Because really wives and children were considered property. Wives couldn't buy land, they couldn't make contracts, and they were just considered a legal extension of the husband. So what happened was, as the women's liberation happened in England in the early 1800s, 1820s, 1830s, and eventually in America in 1830s and on, the women wanted to have be able to say, hey, we want rights. And so in America, women were saying, hey, we want constitutional rights, because how can we be looked at as property, or the man's property, under what's called a coverture laws that was under common law, and that was based on biblical principles of headship and submission. And they said, wait a minute, how can we be, how can we have constitutional rights if we don't even, if we're underneath the property rights of our husband? So as the women were starting to rebel from their husband and starting to rebel from natural family life, that's where we also started to see in 1870 where the Child Protection Services kind of was birthed. And it was actually really birthed, it was an individual, Mary Ellen, you'll probably hear about her in Child Protection Services, 1970, she was a Christian. I believe she was a teacher. She saw a young girl about 11 years old was being malnourished and beaten every day. And so she went to the police, she said, police, why don't you go ahead and look into this matter and see this girl? She's totally getting beaten up. She's getting neglected. And the police says, well, children fall under property rights. And we really can't do anything against parents unless we catch them in the act, because abuse and neglect are criminal actions, but they have to be, there's a strict, you have to have witnesses, right? You're under a higher level of evidence. So the lady who was looking at the Mary Ellen case, she went to the two gentlemen that were in charge of New York of the prevention of abuses of animals, or the rights of animals. And she went to them and she asked them for their help. And from them, they created a society that looked into the abuse of children. Then eventually they asked for more help. They went to the state, which you never should go to the state, but they looked for the state for more funding and more right. And as this then eventually was regulated through the federal government in the early 1900s, then eventually grew to the child protection services that you see today. So what started off as innocent became a catastrophe as the government found a way to get into the individuals' homes.
Right. And a lot of people are saying, don't even let CPS into your home.
Yeah, and it's a horrible two-sided, because the way it is right now is that they know that if you don't let them in the home, right, they're pretty much the judges are pretty much the rubber stamping all these warrants. Two, the police are going to be able to help the child protection services with or without a warrant. They don't care. And they have laws that say that, hey, if they walk into a situation and they believe that there's an extreme dangerous situation, that they can enter without a warrant. And also because many parents don't know about these laws and their rights, is that when a child protection services walks up and says, hey, I have a verbal order, a verbal warrant from the judge that says you need to hand me over to your children, we'll just look them over for the day. You'll more than likely get your child tomorrow. However, if you don't give us your child today, and they're coming with a police officer who's armed with weapons, he says, if you don't give us your child today, you better believe that we're going to come by force tomorrow, and you'll be looked at as a parent who's not working with the government, and obviously you have something to hide. So most parents who are in this situation for the first time, they will give their child to the child protection services without a warrant. And once you do that legally, it's legally considered surrendering your child to the child protection services. And it's the same as if you walked to child protection services and you dropped your baby at the door and you walked away. It is called surrendering your child. So if you give your child to a child protection services person, even if they promise this just for a day, or even if they promise that there's a verbal, warrant somewhere out there, or there's a warrant and, it's just not, it's signed, but it's a bench warrant and they just don't have it with them, or whatever they claim. If they take your child, it's considered that you have voluntarily surrendered your child to the government, and there's almost no chance you're going to get your child back, because once you surrender your child voluntarily, it's almost impossible to get your child back from that point.
This is just a disgrace, because all we're hearing about now is child trafficking, and those numbers are growing even more. And it doesn't seem like there's going to be an end to this. And
no, it's not. And we know it's going to get worse, because what's really important, that a lot of people are activists, might be familiar with what I'm saying, but what they're not or what they're not knowledgeable of, is how the United Nations is handling protection of children, or the best interest of the child standards. And what they're doing is they're trying to emancipate their children, and children, they've been practicing the best interest of the child longer than what we have. But through the best interest of the child standards that they have through this UNCRC, or the Conventions of the Rights of the Child, they are basically doing everything that we're doing, but doing it way worse. And the government is going in and taking these children at a moment's notice. You'll hear it's really bad in the UK as well right now. It's the United States has a little bit of a rule of law, but the problem is when you have a court of equity, right? The rule of law only exists in a court of law, not a court of equity. Juvenile courts, family courts are 100% courts of equity. They're not courts of law, and they will tell you that. That means they don't follow the rule of law. So that's why the best interest of the child standards are so vague, because what it's designed to do is to give that judge 100% discretion. Now, what the government is doing is taking, there's a little bit of a money trap going on right now. And the money trap says to the states, because of Title IV defunding, that gives basically 60 cents on the dollar for every dollar that the state spends on being able to get involved with child protection services, or to be able to collect monies in arrears from parents who are supposed to pay child support.
Mm-hmm.
What
Mm-hmm.
happens is that there's a big, huge pool of money. I think in my state, in Minnesota, they give out, they have a pool of money of $17.5 billion every year that's given to the child protection services, and the federal government is paying the majority of that. So the pressure for the state is that the only rule for the federal courts to give this money to the states is the federal government says, well, whatever your numbers were last year of taking children out of the home, they have to be the same or greater. Now, if they're not the same or greater, that will drastically affect how much of the millions of dollars every state gets from the federal government every year. And so the states are afraid not to have those numbers low. So when Child Protective Services tells you there's not a quota, that's not true. The quota is that the state has a certain number of children that they have to match from last year. Otherwise, they lose millions of dollars, or possibly millions of dollars every year in federal funding to be able to. And so what happens is, when the state says, okay, and they get blank checks, these checks don't have to be spent solely on child protection services or be spent on collection of funds in the rear. They can be spent on your local highways, as far as what I'm understanding. They can be spent on anything. They're just really a blank check given by the federal government. So the state becomes dependent on these numbers and these checks from the federal government to be able to give you the quality of life that you live today. And by that, the states say, well, we don't care what happens to the children after we take them from them. We just need people to take them from them, so we get the funding from the federal government. So what happens is basically the state approving, all the states approving children to be taken away from the home for little to no violation or abuse or neglect. However, who's looking after those children after the state allows them to be taken that's no man's game. So you're looking at people who, once they're involved in the foster care system, these children are pretty much abused, neglect from the very get-go, because the state doesn't care, because the state already has its money. Does that make sense?
Yes.
And the federal government's not going to be at fault, because they claim federalism, that the states are allowed to abuse life, liberty, and property without the federal involvement. So the federal government is not going to get involved in state human rights violations. So the important thing to know is that our promised inalienable rights from the Declaration of Independence stopped existing in 1833 on the Supreme Court, United States Supreme Court ruling, when they said the states don't have to honor your Bill of Rights. So from 1833 on to today, the states have been abusing their power, and the federal government, because of federalism and the 11th Amendment, they're not overturning bad state court decisions.
So technically there's no parental rights. Technically there aren't any.
There is no human rights. And that's the important thing to realize, is that parental rights are part of human rights. So the unalienable rights is a human right, right? You have the rule of law, which is like, you can see those in criminal court cases, the United States Supreme Court and federal courts. However, when it starts to fall under human rights, it becomes a little bit tricky, because under human rights, it falls under the 14th Amendment due process. But however, the federal government says, well, the state can do whatever they want and we're not going to touch them. And the state's saying, hey, we don't have to really give you due process because we have zero oversight and we're protected by 100% judicial immunity. And we're not being sued in the federal courts under the 42 USC 1983. That's not effectively going through those lawsuits. So they're going through with 100% immunity. And plus, if you sue an individual, you're only going to be suing the state. So those people individually usually are not going to lose any money personally, even though those federal lawsuits were supposed to be able to sue somebody directly. But realistically, like if you sue the Child Protective Services for violating your rights, you'll just get money from the state. And basically all the tax money, you just get your tax money back and other people's tax money. So they don't really have any consequence for any of their sins. There's no consequence for them violating your human rights. So we have zero human rights in the United States. And that's all this happened because of the states, because of the 1833 ruling of the Supreme Court and and after the 14th Amendment, the federal government just refusing to help us out. And so recently, you probably heard this. So President Trump was appalled that when he heard that there's about 500,000 children in the foster care system right now, and the way that the foster systems run right now is that legally, if children go missing, stolen, runaways, anything, if they go missing legally, they don't have to report the children missing. So there's many cases of these children who are being sexually exploited, who are being sold, and other things. As a matter of fact, right now, if you look at the nation that's has the highest sex trafficking, the United States is number one. So the United States is the highest ranking for sex trafficking over children.
Well, I just don't know what to say. It's just very discouraging that this is happening. It's gone on for so long and we can't control it. Is there a way to control it?
So what happened? Yeah, right here. Yeah, and what happens is I was talking to the director of parentalrights.org, and I was talking to the director the other day. I talked to a good number of people just because of I'm an author in the book I wrote, and just people are really friendly. But all in all, the parentalrights.org, they realize that if you look at any kind of movement such as the women's suffrage movement or the civil rights movement, they realized that changing the laws wasn't going to do anything. They realized that they had to make an amendment. They had to amend the Constitution to be able to, for women to have the right to vote, or for blacks to have, the freedoms that they have today through they amended the Constitution. So the parentalrights.org, they're trying to put through a parental amendment through. However, this is very, very unsuccessful so far. They're putting a lot of effort into it. They're talking with legislators, they're talking with Congress, but they're really not getting anywhere the support that they need. And they're getting a big pushback. And surprisingly, the people who are pushing back are the American Bar Association and the National Organization of Women and some other federal feminist groups. But it's important to realize that 60% of Congress as of today are bar certified. Now remember, bar is a certification. It is not a license. You are licensed through the state to be an attorney or a lawyer, but you are certified through basically like a Club Med of lawyers that was designed, I think, originally in New York around 1875. And it's a monopoly on law. And so this monopoly on law, which was basically a private organization, this is not a government organization. The bar is not government, it's private. And you have to pay dues. And with these dues, they're able to control the law. And right now, the Bar Association is the #1 proponent against 50-50 shared custody, fighting against unilateral no-fault divorce, fighting against any kind of change in Congress or the legislative regarding family or divorce or child protection services. They're claiming that they're doing it for our own good, but they have a very hard liberal agenda, and they're very open about it.
It's just, it's overwhelming. It's just all overwhelming. I'm glad you wrote this book. When did you decide to write this book?
So this book is it's a theological doctrine on looking at divorce and remarriage in the first century church. What it does is it takes a look at the ancient Israel Jewish marriage practices from the Old Testament and some of the just some of the practices that they would have, customs that they would have in Israel. And these were based on unilateral laws, such as bride prices and dowry, and the father giving away the bride. And the women wouldn't have the right to be able to initiate a divorce because of the bride price, because the women were acquired through the bride price, and the authority of the father was transferred to the young man. So they didn't have, because of the authority, they didn't have the ability to divorce their husbands. Well, what happened was the Romans had Roman occupation, occupied Israel in the first century. So what we see is, like in the biblical times, in the New Testament times, we see Israel has unilateral laws in regards to marriage and divorce. However, Greco-Roman, or the Romans, had a bilateral system. And through this bilateral system, women were allowed to initiate divorce. And so what happened, there was a clash between the unilateral system and the bilateral system, basically patriarchy and feminism in the first century church between the Jews and the Greeks. Now, I know that's a lot, but with that, what we did was I went and spoke to a few, I spoke to like a law professor and a lot of other theologians. And what we did is we looked at unilateral and bilateral contract law and how it clashes. And then we were able to see a lot of the similarities in the first century church. So now this is not applicable for family court. This is applicable for the churches and the pastors to be able to look at, hey, how do we have a patriarchal Bible, and how do we exercise that in a egalitarian world or a feminist world? And it's because the same thing happened in 1 Corinthians chapter 7, as Paul had to deal with Jews and Gentiles with different ideologies. But through that study, I was able to take a lot of the history as well as contract law, and I was able to apply those concepts to the unilateral social contract of the Declaration of Independence and the unilateral social contract of the completion by the Constitution. The Constitution is basically a completion of the Declarations of Independence's promises. So I was able to apply that stuff, and from there, with a little bit of historical research and asking people questions, hopefully are getting a little bit better idea of how we got into this mess. Is there any way to get out of it? And the simple answer is no. As long as we have courts of equity dealing with family court, we have zero judicial protections. The federal government's not going to protect us. The state government's going to abuse us. The Child Protection Services is going to make tons of buckloads of money off of our children. Unilateral no-fault divorce, women are going to use unilateral no-fault divorce and are just going to divorce their husband at the high rate of divorce that they're doing right now at 83%. So we're going to be looking at a complete destroyed America in a very, very short period of time. Unilateral no-fault divorce came from Russia in 1910 under Marxism. So that's unilateral no-fault divorce was designed in Marxism and basically almost destroyed the country. And they had to really reverse their unilateral no-fault divorce laws because they saw the even under Marxism and socialism, and even though they wanted the family unit destroyed, they realized that their nation was going with it and it was out of control. Unfortunately, the United States did not learn our lesson. And the lawyers who knew the law and knew the history took advantage of the history, took advantage of us, and put us in a situation that we can't reverse. We can't reverse unilateral no-fault divorce. We can't reverse child protection services. We can't reverse the federal government to help us out and protect our human rights or protect our life, liberty, and property, or bad state court judgments. There's no way for us to get out of this. And we are trying very, very hard to change legislation to get rulings in the federal court cases and the Supreme Court cases and state Supreme Court cases. And we're going to keep on fighting, and we're going to keep on inching and inching. However, the liberal agenda is growing way too fast. The government is gaining way too much power, and we're getting only little teeny strides of accomplishments. And so if you look at 10, 20 years down the road, going at the rate that we're going today, there will not be any more America left.
Right. And I read somewhere that the birth rates are dropping as well.
Yeah, 40% of all children in the Black community are born out of wedlock. 40%. And so what happens is that when you're dealing with having children born out of wedlock, you're having divorces that are over 50%. And then you also have, since 1980, you had cohabitation increase 900%. When you start putting those statistics together, people realize it's not safe to have children anymore, because the family unit was designed to protect the child to be raised in a secure and nurturing environment with both the mother and father, because the father has to work by the sweat of his brow all day and all night. That was designed. And the woman was to stay at home and to be able to feed, take care, nurture, and to protect the child, and to be able to control the house and so forth, and bless the house. And so the father and mother had individual roles that blessed the entire family. However, a father cannot raise a child all by himself, and a mother can't raise a child all by herself. As much as we would like, you can't do it even in today's society. Child Protection Services knows this, and they're able to take out children by the thousands, if not hundreds of thousands, maybe almost I think 1 million right now. 1 million children are taken out of the home, I think, by Child Protection Services every year. Right now in the United States is 1 million. Because they realize that you simply can't have a nurturing family unit with one parent. And the problem is that statistically, when you start getting in step parents and half siblings, we start to see sexual abuse being raised. We start to see that raised really high. And so because the step parents don't have a natural affection or a natural connection to these children, statistically. And so we're seeing a lot of children who are being sexually raped. I think it's 1 in 4 by somebody who's either a family member or a close family member. It's the statistics are just horrendous. Now, there's no one who's going to love a child like their parent. And Jesus spoke about this, right? Jesus said, who's going to protect the sheep? Is it going to be the shepherd, or is it going to be the hireling? And Jesus said, I assure you that when the wolf comes, the hireling will run, because he cares about his own life. And he goes, but not the good shepherd. The good shepherd will lay down his life for the sheep. And who's the good shepherd when it comes to children? It's the own biological mother and father. That's the good shepherd. That's the good shepherd that God designed. And anything else is a perversion of what is perfect.
Well, that's for sure. I'm so glad you're explaining all of this, because we had talked, I think it was even months ago, about this, and we should have had a podcast back then. I mean, have you been to family court at all? Have you been through the hell other parents have been through?
Yeah, well, right now, and I have too, and that's how I got involved, because I had I've been studying for 25 years on divorce and remarriage, and writing my book for 25 years for Bible college. And so basically, when I went through family court, I was able to see the real violations of everything that was happening, the moral violations, and saying, how could these judges make these decisions? So I want to let you know right now that there is an attack, not only on what's good, but there's a direct attack on Christianity. And if you're a Christian believing to raise your child in Christian principles, in Christian ethics and Christian morals, okay, you will be attacked. And the way that the court system attacks you is that right now what they do is they'll assign therapy. That's their way that they will attack Christians. So they'll typically say that, oh, this person needs therapy, because really they don't have really anything against Christians. But if you say, hey, spare the rod, spoil the child, or you believe in headship and patriarchy, or you believe in homeschooling, or any of these other things, what the judge knows is that they can't attack you directly, but what they can do is they can assign you to have therapy. And when the judge assigns you to have therapy as a Christian, then he can kind of get you in a elongated, controlled environment, because they're really looking to control you. And they really don't want you to get the child unless you're willing to obey what the government says. The government's not looking to give the children to the better parent. The government's looking to giving the child at the parent who most represents them, right? We worship God in our own image, And so what happens is the judge is going to give, or who's going to say the better parent is the one who looks more like him or her. And right now, the judicial system is not run by Christians. It's run by the world. And the world is going to give the children to those who will parent like the rest of the world. You know, you're looking at public education where we have LGBTQ being pushed down, shoved down the children's throats.
Mhm.
We have mandatory reporters, so much so that parents now are afraid to bring their children to hospitals or bring them to school. And knowing that Child Protection Services can take children out of the school now, and it's easier to take children directly out of the school rather than to try to get them at home. So it's like I said, this is it's a horrendous thing. If I could tell you of anything, it would be, as a parent, get your child out of the public school system. Raise your child right now, because you better believe that morality is being taught to your children. It's not education, it's morality, because they're trying to push an agenda, and that agenda says that, hey, whatever is legal is right. And right now, homosexual couples and gay couples and transgenderism, those things are legal. So when it's legal, it's right. So the way that they try to brainwash or try to re-educate the people, and they're doing that through your children, and they're doing that through the public school system.
Well, I notice even in the libraries, they're doing it like library time.
That's
They're
right.
doing some things there. I just don't know. I just cannot believe society has changed this much. I wish I had studied sociology more, and I just can't believe this is what's happening to our country and our children.
And it's not
And
even our country, right? It's actually happened worldwide, because the United
right,
States is the ruler, because whatever nation has the most money has the most fun, right? Because we have all the great movies, and all the women have, they're wearing anything they want, and the kids are all have driving cars and Xboxes. This is like the American dream, and everyone around the world wants to be like America. So what they do is they also want to emulate our Constitution and emulate our laws. And by
mhm.
doing that, they're also emulating our immorality. And so right now around the world, even in strict Muslim and Jewish communities, we're starting to see the Western influence being predominant. Women divorcing men, separation of children, the United Nations being able to emancipate children with the best interest of child standards that they have in their convention and articles. So, like, a long story short, it's not happening just in America. It may have started here. It kind of started in England, then some of the rebelliousness started here in America. But again, if you have a child, if you know that you have a child, right? If you
Right,
do 100 things good, but then you swear and you cuss if you bump your toe in the middle of the night, well, guess what your kid's going to remember? They're not going to remember the 100 things that you did good. They're going to remember the swear words, right?
right.
Because sin is always more pleasurable for the moment, and it's easier for people to pick up bad habits than it is good. And so the rest of the world is emulating the United States, but they want to emulate the sexual morality and the perversity and everything else, and the court systems and everything that we have here. And the United States has actually, even though we were designed to be a Christian nation, we have perverted a lot of this world with our Western world ideologies and perversity, and because we worship sex, right? We worship sex
Mhm.
outside of the marriage unit. That's what we worship. And that has created a downfall of children being born out of wedlock, abortions, and so forth and so forth.
Well, that's very true. It's a global issue, and it's all these countries are complaining about is the same thing the United States parents are complaining about. So this is everywhere. This is going on everywhere and in every country.
That's right. Yep.
Where can people find your book if they're looking for it? Where
Now,
can they?
yeah, sure. My book is free, and it's a Christian view regarding divorce or remarriage, looking at several different elements of law, biblical, legal. However, it's not dealing with family law. So I like to make it very clear that If you want to know doctrinally what we should do for divorce and remarriage, the book that I wrote with the help of a lot of other scholars, that's a great book to be able to read, and I think it has some really solid doctrines that hasn't been preached
It
before.
does. Yep.
But if you're looking at family advocacy and your child's been taken by Child Protective Services, you're just not going to have the emotional or the mental capacity to read something like this, nor should you. And the wonderful thing is there's a lot of people like myself, you, there was Michelle McDonald, who I met yesterday, and it's wonderful, mostly Christians, but wonderful people who are willing to help you. So if there's any listeners right now who are going through a tough time or struggling time, get on your Facebook. There is tons of people who want to help you what they can. Now, we have limitations as far as we can't necessarily give you legal advice, but we can educate you. And
Right.
there's a lot of people who are willing to do that for free and to hold your hand. And trust me, if you're listening to this program, chances are you have been hurt, or you will be hurt, or you know somebody who is hurt.
Exactly. Is there any last final words you'd like to add?
Just keep on keeping on. We got to keep on fighting to not lose hope. Trust in Jesus. As far as when we look at the Bible, these are looking more and more like the end times of the last days.
Right.
And in the last days, we see this one world government. We see the dragon with the head, 12 heads, and we see the beast and the false prophet and the Antichrist and all that stuff. And we're starting to see that all come to play. And every single religion for the first time in history has actually said that they believe their Messiah is coming, and they believe their Messiah is coming soon. This would be very much like a warning signal. And if you look at morality is a sign, because Jesus said that he is going to come quickly, lest we destroy ourselves. So you can tell by the morality and wars and rumors of wars, of pestilence, the increase of that means that the time is drawing close.
And you're like the third person to say that to me this week, believe it or not.
Amen. Yeah.
Really,
Amen.
I'm not kidding you. I'm so glad I had you on as my guest, Michael Sayen, on Slam the Gavel. It's a podcast to help the public understand what really goes on in the family courtrooms that in turn perpetuate into parental alienation. I'm your host, Parens Patriae, author of Dismantling Family Court Corruption. Please join us again in the future for another exciting episode. I thank you again, Michael Sayen, for being on. Thank you so much.
Yeah, praise God. Thank you.
Thank you.